I come from Quebec City, as you might notice from my accent, but I've been in Ontario for over 25 years. I started my law practice doing everything that a family law lawyer does, including really, really difficult court battles. And I, at some point, got exposed to collaborative negotiation. And it makes so much sense in terms of the value that it brings to a family dispute, which is very, very emotional and complicated and can really be devastating for many, many years. So now I practice solely out of court, and I specialize in helping families transition from one marital state to another in the best way possible. I also come from a family business where my first-generation founders had a daycare center that started in my basement, and I was both excited to see all the kids come, but also really mad that they were taking my play space. Anyways, all my siblings did not follow suit. We didn't really know how to cherish the business and the values that had been created in my childhood, and we all went our separate ways. But I learned a great deal from being involved and seeing the efforts that are required to be cherished as a owner, because you do spend a lot of time doing that. So we did see our parents not really available to us that much, but there was also a lot of learning and leadership and entrepreneurial spirit that we all inherited. I'm now also a co-founder in the first generation in the field of neuroscience, where we apply neuroscience to help people manage their emotions and behavior, which my spouse runs on a full-time basis while I focus on my family law business. So in our society, unfortunately, marriages continue to be unstable. According to the Vanier Institute, which is a very well-respected research institute in Canada, 38% of marriages will end up in divorce. That's a fairly stable number. It's much higher for common law unions, and unfortunately, second relationships fail at a higher rate, and third relationships fail at a higher rate. The average length of a marriage is 13.7 years, and marriages are likely to divorce within the first, more likely to end within the first 4 or 5 years of marriage. So that's the environment that our children are getting married into, and it is a very unstable situation, and we all work hard to build our resources, and it's uncomfortable when other people come into our family unit and potentially could have access to the wealth and the business that has been accumulated. Why I'm here today and what is important to me in this conversation is to try to show you why certain marriage agreements fail and how to do them so they don't fail. Because really, it's very, we spend a lot of time and money designing them, and I'm at the other end of it as a family lawyer, where people come in and say, can I try to challenge the agreement? Will I get more if I challenge the agreement? And the answer I have to give them is, yes, you can try to challenge it. So I would like to speak to you a little bit about how to avoid uncertainty in situations where these agreements would be reopened. A poor negotiation of an agreement will impact the relationship of the couple that's getting married, and will also impact the relationship of that generation with the first generation, which usually are the ones that want the second generation to have an agreement. So let's start at the basic. What is a prenup? A prenup, we refer to it as prenup, but the legal term is a marriage agreement or cohabitation agreement. So if you do it when you're getting married, it's a marriage agreement. If you do it and you're living common law, it's a common law agreement. It's a cohabitation agreement. But I'm going to call them prenups for today. So a prenup is a written contract between two people who are about to marry or live common law, setting out the terms of possession of assets, treatment of future earnings, control of the property of each, and potential division if the marriage is later dissolved. So who needs one? Their substantial assets or high income, family legacy, someone comes in and they have a house or a business or shares. It doesn't have to be a family enterprise. But if there's a disparity in income or assets, usually the one with more will want one. There are children of a prior relationship. Very often it's understandable that we want to be happy with our new partner, but we also want to make sure that what we've built will be going to our children of a prior relationship. There are potential inheritances or share issues. We see that a lot with when the first generation is embarking on a continuity planning or share transfers. Very often we think about what will happen if these people, the recipients, would be in a marriage and that marriage would not make it. And we see this one a lot, of course. Someone had a bad experience in their first divorce. They're getting together again, and they want to make sure that they plan an eventual breakdown in a manner that's more comfortable for everybody. I'm working in a situation right now where the generation two, the two sons are working in the business. And one has, they're both married, one has a prenup and the other one doesn't. And the one who doesn't have one, his wife is more wealthy than he is. So even within one family unit, the needs to have one might be different, although I think that it makes sense for everyone to have conversations and plan out what would happen if. Why are they so complicated? And it's very trite, but basically what we're saying is we're trying to convince a spouse with a lesser portfolio to take less than the law would otherwise provide for them. So if you see that as a backdrop of the conversation, it is very unpleasant for everybody. It's like saying from the get-go, I love you, but I don't trust you. So how do we navigate this very difficult conversation? I had a situation where a person very close to me was marrying a second-generation son, and the enterprise was very successful, and they wanted her to sign a prenup agreement. And she spoke with me about it, not really understanding what were her rights in this situation. She understood why they would want that, but she was uncomfortable. And she ended up not signing one, because other members of the family that had married into the business or into the family were not asked to sign one because the business was in a different stage then. And when it came to her, the business had grown substantially, so there was more to protect. But she was more uncomfortable because they were going to have children, and her career was going to take a step back, and she just didn't feel comfortable understanding how this was going to play out for herself. So sometimes there are good reasons to have one, and the dynamic of the people involved is such that it doesn't get signed. So there are very good ideas. They're very, very complicated legal agreements. And there are ways to do them in respectful manners. Very, very, very briefly, what can go in a prenup? Limits on division of assets, limits on spousal support. Limits on division of assets is easier to see and understand. Family shares don't go into the new family unit. They stay excluded. Gifts and inheritances are also protected in the law, but they can also be placed into a cohabitation agreement or marriage agreement. What's more complicated is the whole conversation around spousal support. And later on in my presentation, I'll talk about what happens sometimes to these cases. So if people are too harsh on the spouse coming into the wealth or the family, and they say you're going to have nothing and you're going to have no spousal support, those are the kinds of agreements that get overturned because they're just not fair. In the case of a person who sacrifices their career and they look after the children and they really support, you know what it's like to be in a family enterprise where you spend a lot of time working at the business and the other person supports you and encourages you and supports the fact that you're not there, and they pick up the pieces in other places. And if the result of the agreement is that they have a very difficult life after the separation, it's not going to work. They will resent it, and they will go to court, and they will try to have it overturned. If it's unfair, it will be overturned. So you can do some things with spousal support. You can limit the level of income that goes in to calculate support. Like I work with a client right now who makes so much money, and if we just let the law apply to his situation, the wife would make more in a month than most of us would make in a lifetime, if you just let yourself be a subject of the law. So of course people want to limit their exposure. There's nothing wrong with that. Sometimes we craft them around the support scenarios increase if the length of the relationship increases as well. It's like a stepping stone. So there are ways to deal with these situations that would otherwise be very scary if they were left to the law. What can't go into a prenup is anything to do with parenting. Because you can't know in advance what the children's needs are going to be, and the children's needs are what prevail. And if you say in the prenup they're going to go to this school or they're going to have this kind of religious education, that's not enforceable. You can't know in advance what your kids' needs are going to be. Limiting or playing with child support is not permitted, because the law on child support is very clear that the income and the resources of both parents are always available to the children. So if you're trying to limit income from the family business or income from a trust for support purposes, it's not going to work. So don't even spend time doing that. So I just spoke on that. Exclude income from the business for child support. That is not going to work. Limits on financial disclosure. This is a very important issue because we're asking someone to evaluate what they're going to get under this agreement versus what they would get under the law. They need to have full financial disclosure, including valuations of businesses and shares and trusts. So it's a very involved process. And if you say, don't worry, don't you know, we're not worth that much, or we're worth a lot, and don't worry, you don't need to see it, that's not going to work. People have to have full financial disclosure. And then anything that's unreasonable, of course. That almost goes without saying, but not necessarily. All right, so this is where it gets really interesting. When is the best time to negotiate an agreement like that? Never. It's never a great conversation. It's never easy for the person that wants to protect or for the person at the end of it. So then the next best time would be when you start a new relationship, not 2 months before the marriage. I know you laugh, but I have these cases where they're stressed out because they have to negotiate this while they're getting their dresses fit, and it's just, you don't do that. So as early on in the relationship as possible. I have a client who, unfortunately for him, but anyways, he's a repeat client, so he has another relationship. He's in 1 hour negotiating a cohabitation agreement. But what I like about him is he is upfront. Right from the get-go, he told his new girlfriend, I come with a marriage agreement. Now, sometimes we would think that that's a bit calculating, but I think it's very honest. Like, if that's what you want to do, why wait till she really loves you before you mention it? Now she's stuck in it, what is she going to do, right? No, don't trick the person. Just be upfront and say, you know, we have a family enterprise, we have a legacy, we owe it to the previous generations, this is what's required in our family. It's a difficult conversation, but it is very honest, and it really helps to, right from the get-go, develop communication skills and conflict resolution skills in the couple. There are some times when a business opportunity occurs and the person is asked to sign a prenup if they're going to hold shares in a corporation. That's very, very difficult to do. I've had these cases where the spouse at the receiving end of it would come to me and say, we've been married for 15 years. I don't know what's going on, but they want me to sign this. Like, I don't know if he's seeing somebody or what. Like, it really brings disarray in the marriage. Sometimes that is dealt with at the corporation level, where they would have an arrangement where the shares would be purchased by the company and they wouldn't pass if there's a divorce. So you can get around that a little bit. So let's do a David Letterman top list. You guys remember David Letterman? So I have a top 5. So let's go with the top 5 reasons that agreements are not upheld. Number 1. My lawyer recommended by my spouse did not represent me well. I know, don't do it. Don't tell the person who they should see. I see that in case law. I see it all the time. They will use it against the agreement. Give them a website. Use the collaborative website and say, you go get someone from this website. But there's cases where, there's one where the wife was working with a lawyer. The lawyer said, I will not put my name to this agreement. And she was distraught. She went back to her fiancé and she said, I don't know what to do. He said, that's okay. My lawyer's friend will work with you. And so the lawyer's friend worked with her. And then, of course, she challenged the agreement successfully years later because it was just, that's not how you want to do it. So let the person choose their own lawyer. It will pay off in the long run. I was told to sign just before the wedding, otherwise the wedding would not happen. That happens. Or sometimes what happens is it's discussed early on and it is an uncomfortable thing. It's like doing your will. People procrastinate dealing with it. There's financial disclosure requirements. It takes a long time to value certain things. It's a very long process. So sometimes it started in the right way, and it becomes so close to the date that it becomes uncomfortable for everybody. So try to manage the timing of all of that. If you're supporting your child through the negotiation, you have to facilitate the exchange of information and the valuation of assets. Another reason is because the financial disclosure was not complete, I didn't understand or appreciate what I was relinquishing. So basically, they have to be able to evaluate, okay, well, if we separate and this is not in place, what do I get? And you want me to do what? And so they need to be able to understand the trade-offs. And a lot of people agree with that, because they say that I'm not with you for your money, and I respect the legacy and the hard work of your family. But they have to understand what the law says, and they have to understand what they're giving up. Very important situation. If I'm left in a vulnerable situation, they will find a lawyer that will be quite happy to go and test the validity of the agreement in the court system. And even if the agreement is really well drafted, just the sheer annoyance of it for the family, they will settle, they will pay up, because someone challenges it and they're afraid of the worst case scenario. Now, I really like this one. This is my top list. My top reason why an agreement is not upheld: there's a nasty divorce. And the aggrieved spouse is believed when they raise these issues. So they go to court. When you negotiated the agreement, everything was fine and dandy. They had their proper lawyer, and then you did all the disclosure. And they're not, the nastiest divorces end up in court, and everything gets challenged. So, my next top 5 list: 5 ways to have a prenup do its job. Raise the idea as early on in the relationship as possible and act on it. Make sure there's truthful and full financial disclosure. Make sure the agreement is fair. Now, fairness is complicated because you don't know what's fair, and what's fair today might not be fair in the future. And I don't have an answer for that. That's the age-old problem for the family lawyer advisor, is what's fair today and is it going to be still fair in the future? But fairness comes into play when judges look at these agreements. Use collaborative negotiation. That is because in collaborative negotiation, first of all, collaborative law is a system of negotiation that is inspired by the Harvard model of negotiations. It's a very intelligent, organized method of negotiation. It's very well suited for family law situations. And in collaborative law negotiation, the way that the agreement is presented is very different than traditional representation. So in traditional representation, someone would come to me and would say, okay, put this and this and this and this in the agreement and send it to my spouse, to my fiancé. And then they receive it, and it's so harsh to receive it in this way. And then they go to their lawyer, and then it's a fight between the lawyers. In collaborative negotiation, no one drafts anything. The two lawyers and the two clients meet. They talk about what they would like to see in there. There's an exchange of ideas. And then someone is picked to draft it, usually the person who wants it. But at least everyone had a say. And the recipient, or the person who's asked to sign this, 100% feels better than if it's just, here, sign this. So you can see the atmosphere of the two is very, very different. It doesn't mean that it's easy. I do have an example of a collaborative negotiation where I was recommended by, so the advisor who worked with the patriarchs referred me to work for the daughter who was getting married. And we did collaborative negotiation. So we all sat around the table, we talked about it. What was the problem in this one is what was communicated from G1 to G2 was different than what we could achieve in negotiation. My client, the daughter, who was protecting the family heritage, really wanted to honor what their parents wanted her to do. And she also really wanted to honor her future husband that she was going to spend her life with. And so it was a very interesting dance between generations of what they wanted to see in the agreement. And the agreement was drafted in a way that my client was very satisfied with how it was done and what went in it. And I think it was a little bit different than what the first generation wanted. But at least relationships were preserved, and it was not that uncomfortable to negotiate. And my number one advice for how to make the prenup do its job: make sure it never gets used. What do I mean by that? Well, I mean that in our society, we spend a lot of money and intelligence planning successions and corporate structures and wealth transfers. But we don't spend a lot of money working on relationships. Now, I know there's family councils and education committees, but really working on the relationship. How many families would give as a wedding present a marriage course? That would be brilliant. That would be showing you love to the spouse that's coming into your family. Now, I know it doesn't happen like that, but it would be really interesting if we, as a society, would spend a lot of time working on relationships, because relationships are often negatively impacted by this topic. This very important topic of protecting the labor of love of a family ends up being a really difficult conversation for the couple and also between generations. So if we invested in teaching our children and the couple, if they invested in communication skills, conflict resolution skills, relationship skills, that, I think, would go a very long way, and then hopefully they wouldn't need to separate and test whether the agreement is going to be enforced. So just to sum it up, fairness, respect, and collaborative negotiation would probably be the best ways to approach these kinds of negotiations. Thank you.